Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now take a look at this. SEC will hold an urgent meeting on a possible XRP settlement in a Ripple lawsuit. Before we move further, there is a new crypto airdrop now taking place on Telegram, which is about to launch anytime soon. Please make sure you participate in this airdrop. The link is in the description of the video. Don't miss out on this. Now let's continue with our video. In the ongoing case brought by Ripple Labs about XRP, the Securities and Exchange Commission (SEC) has unexpectedly arranged a meeting to discuss the possibility of settling. In the ongoing legal dispute that has been going on for years regarding the regulatory status of XRP, this discussion behind closed doors may prove to be a turning point. Attention should be paid to administrative proceedings and litigation. During the emergency session, important matters will be discussed, such as establishing administrative processes and their resolution. The resolution of litigation claims regarding Ripple will also be a primary topic of discussion during this meeting. The outcome of this court dispute, which is based on the question of whether or not XRP is considered a security, has had enormous repercussions for Ripple as well as the cryptocurrency sector as a whole. In spite of this, the Securities Exchange continues to argue that the organization's acts violated the United States regulations by issuing the token without the appropriate registration. A potential compromise has the potential to completely alter the feeling of security surrounding digital resources. A settlement could have a potential impact on the market. A merger has the potential to have significant repercussions for the cryptocurrency industry, particularly with relation to the future of XRP. If the Securities and Exchange Commission and Ripple can agree, it may shed light on the coin's genuine position and affect the way other cryptocurrencies are governed. As an additional point of interest, it is anticipated that the ruling in this case would establish a standard for the classification of digital assets. In particular, the exchange price of XRP has been subject to changes throughout the case, which has caused stockholders to feel concerned. If a settlement is reached, it has the potential to stabilize the value of the token and provide reassurance to those who held stakes in the project. At this point, however, the specifics of any deal are still unclear to the parties involved concerning the regulation of cryptocurrencies. What could this imply? Is it possible that this agreement will result in more extensive control reforms for virtual assets? The outcome of the case filed by Ripple is expected to have an impact on how regulators in the United States treat the sector in the future. This meeting may not only have the capacity to influence the future of XRP, but it may also be a potential indicator of the broader ambitions of the blockchain sector as a whole. As a result of the SEC's appeal of Judge Torres's recent order, the price of the asset experienced a significant decline. Even though the XRP community has initiated a petition in opposition to the SEC contention, it does not possess the legal authority to halt the ongoing legal procedure. Members of the XRP community are dissatisfied. The legal dispute between Ripple and the United States Securities and Exchange Commission, which has been going on for almost 4 years, has taken on several new developments during the past few months. In August, Judge Torres issued a finding that ruled that the sales of XRP on secondary markets to individual investors did not constitute securities transactions. This ruling was a significant event with significant implications. Ripple, on the other hand, was compelled to pay a fine of $125 million for violating some securities regulations, taking into consideration that the penalty was a 94 drop from the initial request for $2 billion that was made by the SEC. The company appeared to be content with the outcome. It was for this reason that many people believed the commission would file an appeal, and sure enough, it did. The announcement was followed by a significant drop in the price of the token, as well as opposition from members of the community. The XRP army went so far as to establish a petition with the title, "Stop the SEC's Unnecessary and Frivolous Appeal in the Ripple v. SEC Case." The primary objective of the endeavor is to ensure that voices are heard. The argument that we are making here is simple: put an end to the SEC appeal in the Ripple v. SEC final verdict, which is without merit. Ripple and its stakeholders are not the only organizations that will be affected by the implications of this case. Not only is it an issue of principle, but it also goes to the basic roots of the regulations that govern digital money. In the petition, it is said that we must protect the interests of all digital currency enthusiasts worldwide who are inspired by the prospects of a decentralized financial future. There are currently over 8,000 people who have signed it, with 569 people joining the campaign in the previous 24 hours alone. The ultimate objective is to collect 10,000 signatures. Could the petition put an end to the appeal? It should be brought to your attention that the judicial system functions independently from the petitions of the general public. Because of this, the initiative of the community does not possess the legal authority to immediately intervene in or interrupt the procedures of the court system. On the other hand, it has the potential to become more widely known and to attract additional attention to the process. XRP reached a low of 50 cents on Thursday, October 3, after the Securities and Exchange Commission submitted its notice of appeal on Wednesday. The docket from the United States Court of Appeals for the Second Circuit was distributed by United States Attorney James Phelan on Friday, which contributed to the losses that occurred on Saturday. The docket disclosed the SEC's intention to appeal both the summary judgment and the ultimate ruling, which is an important development. Concluding statement, important particulars about the third component of the Howey test. Judge Elisa Torres concluded on July 13, 2023, that programmatic sales of XRP did not meet the requirements. After this, the Securities and Exchange Commission submitted a motion for interlocutory appeal, requesting permission from the court to appeal the verdict. The request, however, was denied by Judge Torres, which meant that the Securities and Exchange Commission SEC had to wait for the final ruling before moving further with the appeal. Former Securities and Exchange Commission lawyer Mark Fagel responded to a post on X that stated the SEC appealed the penalty amount rather than the judgment, that XRP was not a security by writing. In addition to challenging the disgorgement and fines, the Securities and Exchange Commission is appealing the decision that programmatic transactions were not considered to be sales of securities. However, this is not the aim of the appeal. In addition, Fagel stated, according to my understanding, the primary objective of the appeal is to overturn the decision of the lower court, which stated that program and non-cash sales did not constitute sales of securities. I am going to assume that they will also challenge the remedies and liability of the persons, but I would not expect them to do this for the sole purpose of obtaining penalties. When it comes to the CC's need for remedies, Fagel concluded that the answer is fines would be increased if the SEC prevails, which is a remote possibility, although none of the money would be given to the SEC. The legal precedent, on the other hand, is of greater concern to them. Specifically, they want to establish the law that the conditions surrounding Ripple sales, an analysis of the final decision and its effects on Ripple and the market, the request of the Securities and Exchange Commission SEC. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.